The events of the past few weeks embody in the most regrettable way the perilous state of the digital asset market. For years, many have recognized that a patchwork of federal and state-based regulation is an unsuitable substitute for a comprehensive approach. We are here today because many Americans invested in a novel product and will likely lose money because digital asset markets lack the basic protections that we have all come to expect and have made American financial markets the envy of the world. In the absence of stringent and uniform standards, the digital asset market rapidly expanded. With nominal barriers to entry for new products and new consumers, massive speculative interest has taken the place of legitimate market forces, putting the American public at significant risk. We are here today because the latest events involving FTX lay bare the consequences and demand accountability. As I have stated publicly many times before, I strongly believe that we need to move quickly on a thoughtful regulatory approach to establish guardrails in these fast-growing markets of evolving risk, or they will remain an unsafe venture for customers and could present a growing risk to the broader financial system. Failure to act will leave consumers who have made investments in digital commodities largely unprotected. Unlike other federal financial regulators, the CFTC lacks the necessary and direct authority to write rules and to oversee this marketplace. Instead, we may only reach it through more limited authority activated when fraud or manipulation has already occurred. While we can and do hold perpetrators accountable when we find fraud or manipulation, for the victims of the scheme, it's already too late. The CFTC does not have direct statutory authority to comprehensively regulate cash digital commodity markets. Instead, the Commission's jurisdiction resides with its more limited fraud and manipulation enforcement authority. In the absence of direct regulatory and surveillance authority in the underlying cash market, CFTC enforcement activity begins with a referral or whistleblower tip from an external source. Despite this limitation, the CFTC has brought more than 60 enforcement cases in the digital asset space since 2014, with total penalties of just over $820 million. Alone in fiscal year 2022, more than 20% of our total 82 enforcement actions involved digital assets. But as I have suggested over a year ago, the fraud that we are able to prosecute is likely a fraction of what exists in the shadows. Limited enforcement authority is no substitute for comprehensive regulation in which trading platforms, dealers, custodians, and other critical infrastructure participants are required to be registered and subject to direct oversight by a regulator such as the CFTC. By the time the CFTC is able to exercise its fraud and manipulation authority, it's already too late for defrauded customers. Identifying unique elements of the digital asset commodity markets that distinguish it from other cash markets, I have asked Congress directly for clear authority to impose our traditional regulatory regime over the digital asset commodity market. I have been greatly encouraged by the efforts from Congress to date. I have not been shy about my encouragement of bills that contemplate shared responsibility for the CFTC and the Securities Exchange Commission, where the SEC would utilize its existing authority and reporting regime requirements for all security tokens, while the CFTC would apply its market-based rules for the more limited subset of commodity tokens, which do not have the same characteristics of security tokens. In September, I appeared before you in support of the Digital Commodity Consumer Protection Act, which benefited from the expertise of CFTC staff who worked closely with some members of this committee to establish a framework similar to the CFTC's current and effective regulatory framework over the derivatives markets. I have been encouraged by the bipartisan and bicameral support that recognizes the need for guardrails around the burgeoning digital asset economy and calls for regulation to impart transparency, accountability, stability, customer protections, and oversight across digital assets. In light of recent events, the CFTC stands ready to continue working with this committee and other members of Congress in revisiting existing proposals to ensure every known weakness, risk, and failure is addressed in legislation. It has been easy to fall into analysis paralysis, compelled to endlessly debate the utility of the underlying technology, how to ensure responsible innovation, and how flexible or restrictive regulation should be, both exclusively around digital assets and inclusively amongst traditional financial instruments. Our highest priorities must be the protection of customer property and promotion of fair, stable, and resilient markets. If we are going to ensure that FTX and other firms that are subjecting customers to billions of dollars in losses are appropriately regulated and held accountable, we need to act promptly to apply a comprehensive regulatory regime. Most of the coverage about FTX in the past weeks has focused on the over 130 different entities that filed for bankruptcy, which includes an offshore-based exchange for trading digital assets and digital asset-based derivatives, a highly leveraged market-making firm trading throughout the digital asset market, and a U.S.-based spot exchange. Of significantly less focus is the entity registered with and overseen by the CFTC, a derivatives exchange and clearinghouse called LedgerX LLC. Since 2017, LedgerX has been registered with the CFTC as a designated contract market, swaps execution facility, and derivatives clearing organization. LedgerX is one of the few FTX entities to not file for bankruptcy. The CFTC has been in near daily contact with LedgerX, as well as the third-party custodians it uses to hold both cash and digital assets. Based on the information presented to us at this time, LedgerX customer property remains secure, and LedgerX has the financial resources to continue operating for the foreseeable future. We are continuing to closely monitor LedgerX, but the initial evidence suggests that in the collapse of the broader FTX universe, CFTC regulations are working to ensure that those registered with the CFTC are in a position to protect customers and continue market operations. The lesson here is clear. Thoughtful, comprehensive regulation works to protect customers and prevent the type of events that have befallen the other FTX entities. Invariably, the questions we are all obligated to answer as regulators are, how did you let this happen, and how will you prevent this from happening again? In the pivotal moment we find ourselves in, the answer to both questions is comprehensive market regulation. At the CFTC, we lack the authority to comprehensively regulate the digital commodity market and to prevent this from happening again. We must be provided appropriate authority by Congress. And without new authority for the CFTC, there will remain gaps in a federal regulatory framework, even if other regulators act within their existing authority. In fact, the recent Financial Stability Oversight Council report concludes that, quote, a regulatory gap exists in spot markets for crypto assets that are commodities and not securities. The CFTC will remain vigilant with respect to our registered entities, use our existing fraud and manipulation authority to the fullest extent of the law, and engage with this committee to ensure you have as much information as needed. I look forward to answering your questions, and thank you for the invitation today.
Thank you very much, Mr. Chairman.